welcome back to a brand new video. There have been a lot of questions regarding whether the Supreme Court can revisit earlier immunity decisions, such as the recent presidential immunity ruling that they afforded Donald Trump, unfortunately, unlawfully, and illegally, and unconstitutionally, this last summer. Let's get into it. A recent question I've gotten, like I've said, is can the Supreme Court revisit earlier immunity decisions and deem them unconstitutional? And the answer to that, ladies and gentlemen, is yes. Yes, the Supreme Court can and has in the past revisited and overturned its own earlier rulings, although it does so with caution and only when there are strong justifications for doing so, adhering to the principle of stare decisis. Ladies and gentlemen, here is a more detailed explanation. Stare decisis. The Supreme Court, like other courts, operates under the principles of stare decisis, which means to stand by things decided. This means that courts generally follow precedents established in prior cases. Overturning precedent. While the Supreme Court generally follows precedent, it is not bound to do so in any case or in all cases. It can overturn its own prior rulings, but only when there are special jurisdictions or strong grounds to do so. Reasons for overturning. The Supreme Court might overturn a precedent if it is deemed unworkable, no longer viable, inconsistent with the Constitution, or if there have been significant changes in social conditions or legal understanding since the precedent was established. Examples of overturned rulings. The court has overturned its own precedents in the past, including in cases like West Coast Hotel Code v. Parrish, 1937, which overturned a previous decision regarding minimum wages for women. how ruling occurs. When the Supreme Court overrules a prior decision, it typically does so in a new case where the court explicitly states that the prior precedent is no longer valid. Frequency of overruling. The Supreme Court rarely overturns its own precedents, but it has done so in a number of important cases throughout history. Constitutional amendments. It's important to note that the Supreme Court's decisions on constitutional matters can only be altered by the decisions on by the court itself or through a constitutional amendment. Yes, sometimes the court reverses itself, usually decades later. For example, Plessy v. Ferguson in 1896 ruling upholding separate but equal facilities for people of different races was overturned in 1954 with the ruling in Brown v. Well, ladies and gentlemen, I hope you did enjoy this legal breaking reporting. If you did enjoy this legal breaking reporting, please consider liking, commenting, sharing, and subscribing. If you want to make sure that you never miss a brand new legal breaking reporting that I post onto the channel daily, or pretty much 5, 4, 3, 2, or even, like I said, daily, which means just once a day, go ahead and hit the bell icon, and hit the all notifications. That way, make sure you're notified of every single breaking legal analysis video that I post onto the channel. Another way you guys can do that is by following me on my social medias down below. I will be updating you guys on there on when I posted a brand new legal breaking analysis video. It will be, those links will be, or those socials, will be linked down below, along with the very important news article, or very important links to list the resources that I used in today's legal breaking reporting. Lastly, ladies and gentlemen, please help me reach and achieve the goal for the channel of 150 plus subscribers. The reason why I am saying 150 plus subscribers is because right after we reach and achieve the goal of 150 subscribers, we have more subscribers to reach and achieve right after we reach and achieve the goal of 150 subscribers. Until my next reporting, ladies and gentlemen, please stay safe, please stay positive, and know that justice will prevail despite Donald Trump and his illegal administration's unconstitutional illegal efforts